I'm going to start sharing my slides now. So just some house rules so that this event can run as smooth as possible. Okay. Okay. Okay, so basically participants, I've as a default, anyone who has joined the forum, I would have muted on entry, and in order to reduce background noise, so that's the reason. And then because we have quite a number of participants, actually for your information, about we have 100 tickets that was taken up, all fully taken up. But on the panel now, I think we have about 43 participants. Okay, so in order to ensure a smooth flow, I would kindly request for questions from the floor at any point in time during this session to please send in via the chat window. So you can quickly type in your questions in the chat window. And then you can also just, if you wish to, you can also request which of the speakers that you would like to direct the questions to. Okay, and at the end of the session, if we cannot cover all the questions from the floor, we would actually get them answered and sent via email out to everyone, so that at least you can have your questions answered. Okay. Okay, so without further ado, I would like to start off the session by handing over the floor to, hang on. Okay, I would like to hand over the floor to Mohan. So Mohan is the Managing Director of Adastra IP. So Adastra is the organizer of today's online forum. Mohan, over to you.
Okay, thank you, Preston, and good afternoon, everyone. Okay, you've come across these terms: intellectual property, patents, trademark, copyright, industrial design. I'm sure some of you all might have some confusion. I mean, there's all these terms. What does it really mean? How are they related? So I've got about 5 minutes, I believe,
yes,
to explain the differences between these terms: intellectual property, patents, trademark, copyright. Normally I take about 50 minutes, but now I'm going to try with 5 minutes. So let me see how I go. Yeah, sure. Now, let me start off with intellectual property, because the others are subset of intellectual property. Okay, so let me just start off with this. Now, any creations of the mind, this is where the intellectual part comes in from the intellectual property. So any creation of the mind, be it in form of an invention, like if anyone now comes up with a solution or a medication or vaccine for COVID, that's an invention. Any artistic work, I mean, if you come up with a painting, a song, a drawing, music. Sorry, I can hear somebody else speaking.
Yeah, yeah. So for those who just joined, if you don't mind, except for the speakers, if you don't mind muting your microphones.
Okay, and then, you know, when you come up with any logos or names, and you protect all this by means of law, and this enables the creator to then benefit from it. They can benefit in terms of recognition or in terms of monetary. So when they have all of this, this is when there is an intellectual property there. So these intellectual creations become intangible assets. So that's where the property part comes in. So it becomes an intangible asset for the creator. So it has a value. Now, the various types of creations that I mentioned earlier has different sort of protection. So that's where the patent, trademark, industrial design, and copyright comes in. And to make it a bit easier for the explanation, if you look at the diagram in front, the handphone has got all these various protection on it. For example, if you look at the brand of the handphone, for example, Apple or iPhone, Samsung, that's a trademark. So when it comes to trademark, you are showing the source of creation of where this product actually comes from. Now, a trademark is can be protected for names or logos. Even colors can be protected as a trademark. Sound also can be protected as a trademark. And 3D marks also now has been allowed to be protected as trademark. Now, where trademark is concerned, it's all territorial. When you file it in Malaysia, it's protected in Malaysia. But recently, we've joined Madrid Protocol, and where one filing can cover various countries. So this is actually good for SMEs because if they want to protect the trademark in various countries, they don't need to go into each individual country, file one and cover in a few countries. So this is good. And but to get into Madrid Protocol, I mean, let's do that another day. I mean, I will take, or if there's any questions specifically Madrid Protocol, I can take the questions later. But just to let you know, where trademark is concerned, it's all territorial. But if someone wants to protect a trademark in various countries, they can go under the route of Madrid Protocol. Now, another type of protection you can see is industrial design. If you want to protect the handphone, the look and feel of the, the aesthetic value of the handphone, then you protect it under industrial design. Industrial design is important in certain industries. The furniture industry, because most of the chairs, the function of the chairs is the same. It's a seating means. But the difference between the chair that probably you're sitting on and the chair that I'm sitting on, the difference is the design. So if you think you have a very special design for your chair, you can protect it under industrial design. Again, industrial design has to be filed with the patent office, and you have 25 years protection for industrial design. Where trademark is concerned, you have your trademark can actually go on forever. As long as you renew your trademark every 10 years, you file for renewal, you can perpetually have your trademark protected forever. But as I said, industrial design is only 25 years protection for the creator of the design. Now, the other type of protection we can see over there is copyright. I mean, when you have, if you look at them in the phone, there'll be a microchip. In the microchip, there's source codes. That source codes will be protected under copyright. And if the handphone comes with any manuals, the manuals is also protected under copyright. So copyright gives you much longer protection, but very limited protection. The protection for copyright is about 50 years from the death of the author. And the other thing about copyright, which is interesting, is you don't have to go to the patent office and actually file for copyright. If you want to, you can voluntarily go in and file it, but it's not necessary. For example, if you sing a song right now, if I sing a song and I take a video of it, and hopefully I don't sing a song right now, or we just leave. But if I sing a song right now and I take a video of it, then I can show that I've created that particular song and say that I actually came up with this song. And I created a song on this particular date. So I have copyright for the song because I can show the earliest date of creation for the song. If another person can come and prove that they have created the same song much earlier than me, then automatically they have copyright for the song because they can show an earlier creation date. So where copyright is concerned, you don't have to go to the patent office and file and get any filing numbers or dates. As long as you can prove the earliest date of creation, that's good enough for copyright. Now, the final and quite an important type of protection under intellectual property is patents. Now, where this handphone is concerned, there are probably 300 patents or more to protect the technologies that's in the handphone. For example, even the panel only has about 100 over patents. Christian, can you put that slide up? So these are some of the examples of the inventions. There's about 100 over patents just on the panel. That means how can the screen of the handphone be a bit more sensitive? That means how can the touch screen be more sensitive? So for that, they have a patent. And then how can it be clearer or brighter? That will be another patent. So there's about 100 over patents, and we've shown some examples over here. And just as I said, only for patents for this one handphone, you may have about maybe 300 patents just to cover the handphone. Okay. Now, where patents are concerned, you have certain requirements in order for you to claim that you have a patent for it. One is it has to be novel. That means at the stage of filing, the invention has to be new. This is where sometimes researchers go wrong, or even companies. They will disclose the invention even before filing a patent. Researchers do it in the form of publication, and companies do it when they go and take part in exhibitions. They'll go and very proudly show, this is my invention, this is what I've come up with. But once they've disclosed it to the public, then the clock starts ticking. You only have 1 year to file a valid application. If you miss that 1 year, you will not be able to claim protection for your invention anymore because it will not fulfill the criteria of novelty, where your invention is not new anymore. So that's one important criteria that it has to fulfill. The other criteria is it must be new at the stage of filing. Sorry, it must be there must be an inventive step. So the test for inventive step is it should not be obvious to a person skilled in the field. So, you know, if you're coming up with an improved furniture, now a furniture maker should look at it and not go like, oh, this is something so obvious. Anyone could have figured it out. So I'm not going to actually, it won't fulfill the criteria of for a patent. And it also must be industrially applicable. The last criteria is quite easy. So the most important thing is it has to be new, and it also should not be obvious to a person's skill in the field. This is a very important criteria that needs to be looked at. So this is whenever someone comes up with an invention, they can always come and talk to us, and we will then be able to see whether they fulfill this criteria or not, and whether they do have an invention. So like patents, like the others, trademarks and also industrial design, where patents concerned, you need to go to the patent office and file. So the first to file is very important. You need to file and you need to secure a filing date. Now, unlike trademarks where I mentioned earlier, you just file one application and you can get it covered in a few countries. For patents, you don't have such a thing. You don't have one filing covers the whole world. You don't. I mean, the closest you have to that is you can file one application and cover maybe in the European countries and also in the GCC, Gulf countries. That's the closest you have. The other thing you have is PCT application. You can file something called a PCT, but PCT doesn't mean you file a PCT, I'm covered around the world. It doesn't. It just prolongs the period for you to get into each country in the world. So in a way, technically, it gives you enough time for you to make some money out of your invention. So these are the differences between, so I've just explained what intellectual property is. Intellectual property is the main body. Under intellectual property, you have patents, trademark, industrial design, and copyright to protect the various type of ideas that you may come up with.
Okay.
I hope that's good enough.
Yeah. Okay. So for those who have just joined us, so we've just started off as with the first speaker, Mohan from Adastra. So I'm just going to, in the interest of time, I will move on to the next speaker. So for those who have questions, I've reminded earlier, you can send them through the chat window. So then our next speaker is Prof. Dr. Noraini. She is the Vice Chancellor of University Malaysia Terengganu. So UMT, their specialization will be on marine science. So Prof. Dato', over to you.
Hello, Christine and everyone, panel speakers. Thank you very much, Christine Mohan from Adastra for inviting me to this forum as we celebrate the World Intellectual Property Day. You mentioned it was yesterday, but appropriately the forum is aimed to look at the role and impact of the IP in these unprecedented times. And coming from the university, I'm also an inventor, researcher. I was at UTM when I met Christine. We work together in terms of managing IP portfolios and commercializing IPs, technologies from the universities. At that time, I was at UTM. Being the patent owner, I had the experience also to the stage that we have industrial collaboration. But I suppose Mohan has mentioned a lot of issues in areas where the researchers need to know, yeah, especially from the universities. So during this time, as we were locked down, I think almost this is the fourth circuit breaker, fourth time that we are locked down. So most of the researchers, as our contribution to the knowledge creation and knowledge transfer to the community, I feel that we can do something in terms of sharing our IP management at the university. For example, this is a timely review of the IP portfolio in our university where we can identify and prioritize and evaluate our intellectual assets. As mentioned just now by Mohan, actually UMT has a large number of different categories of the IP, more than 250 as we have seen, a lot more 180 in the copyright. But what I want to share here, because of working from home, the researchers are not doing their own research, but we hope that there are certain issues and problems addressed by the country, especially in terms of getting the products and helping the farmers, particularly in getting the fishery sector, as mentioned by Christine just now. So since April early this year and May, we have the Deputy Vice Chancellor just now, you have seen on the screen, has been starting the forum, have kicked off the forum on the 18th. But as you can see, we have this forum on the aquaculture services to share with the community in terms of gathering people and gathering the experts to share their knowledge. And some of them have their own IP from systems, breeding technology, as well as the products for aquaculture feed. So from here, from 12 April and 19 May, we're having all sorts of programs, especially in the breeding technology, which is the forte of the university, from fish to shrimps to crabs and so forth. We also give advice to aquaculture farmers on the diseases and what we can do together. So this is going to be on WebEx. So we invite everyone again after this forum. Okay, so next is we have also the online survey. Next slide we can show. Can show on the next slide, Christine.
Oh, sorry, I think I don't have this online survey, but I can send it out to,
just to show you what we have in the university is actually people. So these people and experts, I'm picking only one faculty, which is the Faculty of Food Science and Fisheries and Aquaculture. So we have the Institute of Tropical Aquaculture, led by Professor Dr. Ikhwanuddin, and we have this monitored by the Research Management Center or the Center for Management of Research and Innovation. We believe that when we get the Malaysian Research Assessment by the Ministry of Higher Education, that we have the MIRA, this is the ranking group where establish the state of the research, and we measure also some of the products is to the IP created. And from this group of people, I just picked here the activity that I've been doing during these difficult times. They are teaching other people and sharing their IP and knowledge and why they're still doing research. So from green farming technology, breeding, fish health, resources sustainability. So I think that's I want to highlight from the university that we are doing today. Also, in terms of tracking a product that's possible that applied, very applied for research, but at the same time that we turn into translate into the benefits for the community. So this is aquaponic production system where the waste from the farm, from where you breed the fish, shrimp or the fish, that we can get the water, the wastewater to actually have for the vegetation. So this low-cost aquaponic system just recently created in terms of to apply for this translational research for the community to utilize during this time where they can use at the backyard. Yeah, they can use at the backyard. Then you can have the supply of food, fish, shrimp, and even all sorts of vegetables that you can do. So if you have an area at your home, or even you can have the multiple, modules of this system, you can have a small to feed the community. So here I show you here that this is an example of industrial design, and that is a product that we can also couple with the intellectual property by doing consulting by the experts from the university. So this production capacity, you can actually come up to 90 kg, and then you can over 3 months to 6 months, you can have the system actually running to have sustainability in the fish and protein and vegetable production. So this is just an example. Perhaps you have the next slide. Actually, I have quite a number. In university, we highlighting the marine resources, oceanography, as well as the aquatic sciences, where the area of the industry that coming in actually through the solutions, products and solutions in environmental problem, as well as the biotechnology. So there are products that, for example, that we have come up in the aquaculture feed, for example, biofloc, artificial reefs, the pyrolysis for waste management, and we have also for what do you call it, biotech for sanitizer, face shields. That's normal because that's immediate need. But what I'm going to tell you is that because of we are locked down, we have copyrights, about 180 of them copyrights. We have a large group of people working on the software, the apps, for various applications, for example, logistics, supply chain. So we believe that during this difficult time for delivering food, you know, distribution of the agriculture products, reaching out to the public, this aquaponic system may be a useful thing, coupled with the apps that we are developing. I believe that could be one of the solutions that the university can contribute to the nation.
All right, thank you, Prof. Dato'. Okay, so that was very insightful. So I just want to just very quickly just take some time to summarize for the benefits of the participants, as I noticed some of you have just come in. So basically, Prof. Dato' Noraini is the VC of UMT, University of Malaysia Terengganu, and she has just taken us through a lot of impactful projects that is very community-based, very industry-based, whereby the university researchers are sharing and are making available a lot of technologies and solutions that are available for them to be commercialized, to be taken up by the industry. So during this period of time, of course, enhanced focus will be on food security, because that's where, you know, during moments of lockdown and crisis mode, I think food is definitely an essential that no one can do without. And so UMT has shared a number of, just allow me to go back some slides. So a number of information and platform that's available for the industry to approach UMT in order to understand a bit more in terms of how they can leverage on UMT's IP to further improve and enhance and strengthen our food security system. Okay, so I will move on next now to our following speaker, Dr. Amir. Dr. Amir is the Deputy Director General, Research and Innovation of Lembaga Getah Malaysia, or Rubber Board, Malaysia Rubber Board. Dr. Amir, so basically some of the questions that I would like to ask you can be found on the slide in terms of the role that LGM is doing in terms of helping the industry, and maybe if you can share with us some of your approach or your IP strategies and approach during times like this. Dr. Amir, over to you.
Okay, thank you, Christine. Mohan, Dato', and rest of the panel. Okay, I see there are quite a number of people from MRB also attending the talk. So first of all, I'd like to say that we are a public research institute. It's a little bit different from the universities, okay? So, and we are governed by an act, you know, it's a government act, Act 551. So under the act, there's about 14 functions, and out of 14, 9 is something to do with R&D. The rest is to, you know, more or less to support the industry. So that during this, what I call time like this, the focus, the R&D is still, you know, going on, like Professor was saying just now, that the researchers are not going to the lab. So what they are doing, we are coming out with proposal and things like that, and also writing papers, you know, try to get things going at home. But in terms of the, you know, what you call the support to the industry, we are more or less looking at, you know, more on the regulatory part, you know, to make sure that the rubber are being tapped, you know, the processors are getting the rubber, and we to produce, you know, we want to see the, what you call the value line to the manufacturer of what you call still going on, because these are income to the smallholders. Now with the, you know, very low rubber price, so it's not helping. See? So so in terms of IP at this time of the, you know, crisis, we are not really focusing on, you know, what you call this emphasize on IP, but more on the service to the industry. Okay, I will talk a little bit on that a little bit later. But just to talk about MRB, okay, see, under our, like I was saying, we have 9 functions of R&D. When you do R&D, you know, we will generate IPs, okay? Like Mohan was saying, we have trademark, patent, utility, design, all the innovation. And over the years, since the Rubber Research Institute time, we have very, you know, quite a big number of IPs, you know, basically patents, you know, we have over, I don't know, countless, okay? But when we talk about commercializing this IP, that is where we to get them into the market, okay? So see, with our sort of industry, the rubber industry, we have a lot of SMEs. SMEs are small, medium, entrepreneurs who are being hit very hard by this. Is what you call this period. Okay, so this sort of industry, they don't have fund. They are not looking like R&D, so they look at MRB. But again, they are looking at the generous contribution to MRB. And then if you look at what MRB have been, trying to commercialize, then it's very difficult for us to get partners to commercialize our IPs. Okay, if it things that take off from MRB, for example, some of our innovation as the SMR, if you look the standard machine rubber, the systemic bearing, some automatic tapping machine, those are things like Mohan said. We publish, we went to conference, we talk about it because researchers would like to share their R&D output. But if we, but lately over the few years, we were thinking that why don't we do commercials? Because because we don't produce more rubber, so our sales money are getting down, recess. So we do have to look at optional, what you call option of getting, fund to fund our research. But to get it, into the market is very difficult. Either we are not fully ready at a commercial end, or we thought we're ready, but our partner are not ready. So there are many challenges. Okay, so what we see that as a public sort of institute, if we were to publish something, the industry will pick it up, one way or another. As you see, one of our what we call a big industry in Malaysia is the glove industry. So most of the processors, technology, and also the raw material came from around time, and we do a lot of research in those, and they took off. Okay, but once they are big and then they can take care of themselves, then they can find whatever IP or whatever they can get throughout the world. They can buy it, or they can get it. So see, I mean, one of our challenges is how to get it out. Okay. So of late, when we decide, we have about 8 products ready for commercialization. But then to get into the what you call this product into the market is very difficult. So currently we are working about 11 partners, okay, industry partners. Same issue because they have to sell the product. That's another issue. And then okay. So in terms of IP, our researcher now feel that maybe a better output for them is to publish paper, because they will be recognized for their promotion and things like that. Because when they start doing patents, they have to pursue it. And when they start going to commercial, they have to look until the end, okay? So that may hinder them from pursuing another, another scope of work. So those are the few things that, a public research institute like MRB have to think, to how to keep our researcher, keep on coming with new ideas, but not burden them with all this, work to where they have to, starting to write patents and then have to, see to commercialization.
I see. Dr. Amir, just as you were mentioning in terms of that is from the internal, the MRB pool of researchers. What about, let's just say, in times like this, so usually, they say that necessity is the mother of all invention. And, tough times like this, there may be people who have come up with ideas or solutions. And can they approach MRB to help to maybe do prototype or develop based on concept or to do certain things which will require your LGM's areas of expertise? Is there a channel like that?
We always do, because our researchers are ready. I think there are a few other that, I mean, in the forum, they are ready with invention, to take up, especially the automation, the IR 4.0. We do have technology, but the one that I'm trying to emphasize today, whatever technology we have today, if our SMEs are not ready to take it up, it's very difficult for us to push it in. Because our SMEs they are 2.0, or maybe 3.0. They are not even, 4.0 is, even 3.0 is doubtful. So,
but now with this MCO, maybe they might start thinking of Industry 4.0.
Yes.
And they might come to you.
We do have a team. I think our team are having all this. We already what you call the value change in the R&D 4.0 for rubber industry. We already look into it. We do have projects, lining up. Now our project are in the process of getting some funding, internal funding. And then if everything goes right, we should be able to contribute to the IR 4.0. But again, our challenge with our industry is most of our industry are SMEs. they are being hitting very hard now, at this time. And for them, maybe this opportunity, they can think back, put a little bit investment, or maybe they can come back to MRB, and we can see how we can support them.
Okay, okay, so that is a good takeaway in terms of, so it's a push in that direction, basically. So, okay, so I will move on to, there are questions that's been coming in, but I will open up later. So thank you, Dr. Amir. So I will move on to our next speaker, Mr. Yagna. So Mr. Yagna, he's the head of intellectual property management, Phamaniaga Research Center. Mr. Yagna, so I will basically hand over to you, and if perhaps you can share your thoughts in terms of in an unprecedented times like this, which really has a great impact on how the medical and the pharmaceutical industry responds to this crisis. Perhaps you can share with us what's some of the things that's been happening lately, and if possible, on the Malaysian aspects as well, because usually we are looking at what's happening in the world, but is there anything happening closer to Malaysia? Mr. Yagna, over to you.
Yeah. Okay, thank you, Ms. Christine and Mohan, for inviting me for this forum. And happy World Intellectual Property Day to you all. Okay, I would start with saying that pharma companies across the world, including Phamaniaga, are trying to do their best to help reduce the impact of coronavirus and helping the governments in whatever way they can. Okay, so we are also ahead in supporting health ministry for whatever support that is offered to us. So, so coming to your first question, how intellectual property rights have been impacted in these unprecedented times, and how it is going to be economic uncertainty. Okay, like I said, yes, it has taken a beat, definitely, but for a good reason. Okay, like if give you an example of Adve product, which is Kaletra, which is a product combination of lopinavir and ritonavir, which has shown a promising results in treating COVID-19. So in response to that, Adve has already dropped their patent rights worldwide, which is paving the way to manufacture the generic products by any generic pharmaceuticals. So if it's the case that Malaysia requires this kind of generic product, and Phamaniaga and other pharmaceutical companies would be in the forefront to manufacture these products. So that is a good gesture by AbbVie to drop the patent rights for this product. Similarly, Gilead is a company which has come up with a remdesivir, which is currently clinical trials are going on worldwide, and Gilead has also come up with a good gesture that they would drop the patent rights in order to facilitate the generic manufacturing, and also they have dropped the orphan drug status. Orphan drug status is one which gives additional exclusivity rights to the any new product. So remdesivir initially was developed for Ebola and showing the promising results in Corona. So they don't want to take this orphan status anymore. So that is a good gesture also. Similarly, companies like Fujifilm from Japan and GSK, Sanofi, they all have in their pipeline actively developing the vaccines for coronavirus, COVID-19 in particular, which may see the light of the day anywhere last quarter of this year or first quarter of next year. Until then, they would have already completed phase 3. But in order to protect these patents or some other intellectual property, that's not their priority in their list. So in case of the countries imposing compulsory licenses, they would be readily giving the rights to any other manufacturer to develop this vaccine. So now the pharma fraternity has come forward to help the world to tackle the situation. That's a very good sign. Okay, we have also, however, we have also seen some of the controversies going on, like China pharmaceutical companies have filed a patent for this Gilead's remdesivir for the usage in coronavirus. Let us see how it goes, whether it goes for a dispute or it goes for a regular examination. So those things are also going on. So by taking these measures by all the pharmaceutical companies, definitely it has taken a beat in terms of monetary benefits for the this one, but it will pave the way to produce medicines in sufficient quantities to support the cost. So that is a good sign. And I have also seen the reports that many countries have already indicated that they would issue compulsory licenses for whatever drugs which are showing promising to cure this evil. So even FDA and US FDA and EMA from Europe are looking at curtailing the exclusivities of some of the drugs. So everyone is going in the same direction to improve the situation and reduce the impact. Okay, coming to the patent filing. Okay, companies like Pharmaniaga is the largest generic manufacturing company in Malaysia. So being a generic company, we file very less patents as compared to the originator companies, but still we have our portfolio going on. At these times, the Malaysian Patent Office and the patent offices worldwide also considered to extend the deadlines for certain timelines, such as I think Mohan can expand on this later, request for examination date can be extended, submitting the reply to the substantive examinations, renewal of the
But you
patents.
can also file it online, but you can also do it online, so it's okay as well. Yeah.
Yes.
But
and yeah, correct. And in-person meetings and oral hearings were postponed and can be arranged through the video conferences. So this will also help patent holders to give a chance to pursue their IP without any challenges.
Okay.
So, and coming to the how industry overall got a hit or taken a beat, like in the manufacturing sector, definitely pharma industry is facing challenges in terms of developing the new technologies. For instance, for new technologies, we may procure new machines, new analytical equipments, which are to be imported from overseas, such as Europe and other countries. So those imports are getting delayed. So the transfer of new technology may be impacted. Similarly, technology transfers, like during this COVID times, any scientists from the research center cannot go to the manufacturing site located in the other states in Terra or to execute the technology transfer. So those timelines are also getting affected. And certainly the raw material procurement. Most of the times, raw material, all pharma industries worldwide depends on China and India to get the raw material. So because the lockdown is implemented in these countries, so securing the raw material is also getting delayed. So there are challenges in executing the regular technology transfers and new pilot batches and new manufacturing batches. And then we also face challenge with the clinical trials and bioequivalence studies. Like for bioequivalence studies, we have to tie up with the clinical research centers across the world, and we have to recruit the volunteers and the patients, and then we conduct the trials. So in these difficult times, we are facing challenges in actually recruiting. Government's not allowing to conduct these trials for other products other than the products that are related to treatment of COVID-19. So all these factors may impact in long term the production as well as submission of new products, and you may see a delay in entering the new generics into the market.
I see. Okay.
But Pharma Niaga is always ready to take any task assigned by the government to manufacture for essential medicine to treat the coronavirus patients for free of cost. So we are actually liaising with the government authorities in terms of whatever way we can help to reduce this impact.
I see. Okay, that's actually very good to know, and very reassuring, especially times like this. Okay, so Mr. Yagna, thank you so much for the update and also an overview of what's happening around the world, the response of pharmaceutical companies, as well as, of course, Pharma Niaga itself in terms of stepping up to the forefront of improving the situation faced by COVID-19. So I will move on to the next speakers. Will be from Mr. Chris Leong. He's the Chief Strategy Officer of SoftSpace. So SoftSpace is basically a fintech company. So Mr. Leong, I will hand over the floor to you. And then if you can just share with us, I won't go through the questions because I think I already sent you the question, and I will just leave it to you to just share in terms of your perspective and generally the company, the impact on your company, as well as how you're responding to this situation. Mr. Chris Leong.
Hi, I'm Chris, actually the Chief Strategy Officer of SoftSpace. SoftSpace is a fintech company. I think we pride ourselves as a payment technology company. So we've been around since 2012, and we've been serving the banks across Malaysia and also in Japan, Taiwan, Indonesia, Thailand. So we're pretty much a regional company. And what we do actually is, you might not see our brand, but you will see our product. If you have seen Order Tesco online and you've seen someone bringing a device to you to accept payments and is tied to a mobile phone, there's actually a product, and that's actually been distributed to CIMB, Hong Leong, Maybank. And at the moment now, I think last year we did a new innovation with regards to transforming a Android smartphone into a contactless acceptance device. So I believe that, most people, before the MCO might not be a fan of using contactless because they might be worried that, oh, if the cashier took my card and just tap on it, what will happen? But now, of course, because you want to have contactless payments, so you basically want to tag and make payments. So, we done something about 2 years ago. We launched with My Debit, which is the national payment system in 2018 to transform any Android smartphone to become a contactless payments. And for that product, I think we won the best e-payment innovation at the Malaysian e-payment excellence awards. And of course, we are recognized by IDC as the FinTech Fast 101 list from 2017 to 2020, all 3 years. And just want to share, we are a very technology oriented company. We are not a company where we buy other people's software or use other people's software and try to rebrand it or try to add on certain stuff, localize it and sell. Most of the product that I mentioned is developed in-house, is developed in Malaysia by Malaysian engineers. So that's something we do. And all the products we talk about is not only a product that can only be used in Malaysia, but it's a product that's recognized internationally. And in most instances, we are the first or the pioneers in these technologies that I mentioned about. So why I want to give you a perspective, because I think based on the nature of our company, the way we look into IP, the way we look into whether we should cut costs on IP in this area, we have a different perspective. If you're a software company or you're a mobile apps company that just develop based on what your client wants, then maybe you have a different IP strategy. But for us, I think we, as a technology company, we look into IP differently. So I think I'll go through some of the questions, but when we look into IP, we look into IP, of course, like what Mohan mentioned. We look into copyright, trademarks, we look into patents, we look into industrial designs, we look into all four. And when we look into IP, we focus on a lot on number one, we need to have a proper documentation process to make sure that whatever we produce can be justified to other people, whether it's our own IP. Because when we assign contracts with other international parties, they will want to know whether we are in breach of other people's IP. So I mean, the IP process must be clear for us. And of course, the SourceSpace as a startup is a very small company compared to and in terms of other IP knowledge, in terms of the speakers before me. But the way we look into it in terms of as a startup, how we measure IP is as a couple of items. We feel that question one, in terms of this kind of time, do we still cut costs on IP creation or IP protection or whatsoever? I think the answer is depends, but we are very careful. We will not stop the protection part, because as a technology company, we see IPs not only as a protection mechanism, it's also as a bargaining tool. Because at the end of the day, when we receive funding from investors, they will ask, how sure your technology is good? How sure your technology is special? And if you do not have an idea on IP, and I'm talking about as a startup, then it's going to be a very big disadvantage. And of course, when investors look into your whole suite of products, you will look into, okay, whether this process, whether you are special, and whether people can block you from going to other countries. And that's a very important thinking process for them. And if you do not utilize this kind of thinking process into determining whether IP is still a core business for us, then I think as a technology company, it's always a core business. But then when it comes to cutting costs, then it comes back to the second question. We produce a lot of IPs. We do POCs, we experiment with different R&Ds, we experiment with different mobile technologies. Some are interesting, some are very more to playful. But I think a lot of times we need to in tandem align into what is the market opportunities, whether there is a market opportunity, and if there is a market opportunity, do we need to go, where are we going to? Certain products are very useful for certain countries. Like I mentioned when we talk about contactless technologies, is it a worldwide product? So if it's a worldwide product, then we need to look into a protection strategy for worldwide or for countries that are focusing on that. So at this kind of time, I think we are focusing on looking into how this whole strategy of ours in protecting IP goes into, and say whether there is a probability of making money from it, and we assign a conviction value, and from that conviction value we decide, okay, should we put some money into investing into this? I mean, the way we look into it, of course, a first thing is we don't view ourselves as the expert, and of course we look into Mohan as the expert in terms of, okay, whether there's some value into it. We are always looking into our views, and sometimes we might miss out in the sense that whether this technology can be used in other industry, and whether it's worthwhile to protect that in other industry as well. But of course, everyone has blind spot, and hence why engaging an advisor will be good. I mean, that's something that we are looking at. And of course, at this environment, and we look into the whole economic scenario in this environment, I feel that depends on what strategy. And to be honest, when I look into the question of how fintech grows, it's exciting, it's extremely exciting, but it's also extremely scary, because we know that money is scarce, and we don't know how this whole thing will go in the future. But what we need to look into, and what we are looking into, is this might be a good opportunity for consolidation. And when you look into consolidation, it always comes back to value. It's always your P&L value, how much your company is worth. But there's always, in terms of value, in terms of licenses, there's value in terms of IP. And I think at this juncture, for SMEs or whoever who has an IP, look into it, they might want to look into it in the sense that if you're looking for a buyer, I mean, a lot of people are hunting for good deals for whatever reason. Maybe that's something that you should look into in terms of valuing your company. Just what's the value of the IP, and how do you package it in terms of getting investment, getting some white knight or getting someone to merge and consolidate. I think there's a bargaining power in terms of that. I think with regards to what is, I think I answer most of it in terms of what startups are looking into, and I'm talking purely in terms of a startup. But when we look into it, I think IP or when you look into advice in terms of that, I think the key questions is, I touched a bit, but I want to summarize with that in the sense that, I mean, one of the key lessons I learned is that I always look into, or SoftSpace look into the area where we are good at. We are good at payments, we are good at fintech, we are good at financials, but there might be blind spots where this particular technology can be used. And I think that is something that I believe as an engineer, we should always look into as a blind spot and see whether, verify it, whether there's something like that. And I think one of the key things is, because before SoftSpace, I was also working for this company called Cradle Fund. We fund technology companies. So I also noticed that a lot of times, for whatever reason, engineers has a habit, and it's a bad habit in the sense that they think that, oh, what I create is nothing special. And so this is a very bad assumption, because at the end of the day, what you create might be easy to you, it might be superly hard for other people, and it might be someone else's buying spot that they do not know. And I think the key question is, at this juncture, I know cash and I know funds are limited, but I think before making drastic decision or making a sweeping statement that, okay, I don't want to do anything about IP, I think it's key to don't assume, and maybe you'll be sitting on some pools of valuable assets that's of value. And I think the last part is always, for me, don't look into IP as only a way to make money on your own. I think in terms of IP as someone who wants to commercialize and has been commercializing technology, I think we look into IP as in a certain extent, as a barter trade, as a bargaining tool, as a way to entice investor, or as a way to actually reduce the commercialization or the technology gaps of other people to go into market. So we always look into that as a way, and that's something that I would advise that for SMEs to look into it and say, maybe there's something that I created long time ago that's of value. Can I be creative with it, and can I actually utilize it some way to get the best out of this situation? I think that's my thinking.
Right. Thank you so much, Mr. Leong. You did such a good job. I don't think I could beat you into summarizing it. So you highlighted a lot of important and critical aspects of how companies should look at IP. So thank you so much for that. Appreciate it. So I will go now next to our next speaker, Mr. Ryan Oh. He's the Chief Technology Officer and Co-Founder of Plus Solar Systems. So the question will more or less be on the same line that we have also thrown to Mr. Chris Leong, just that on Mr. Oh, I will hand over the floor to you to share with the participants some of the aspects and understanding, and also the impact on your company, the industry, and what are the things that you can just enlighten the participants in terms of what we can do as an industry, and share your thoughts, especially for the other SMEs. Mr. Oh, over to you.
Sure thing. Thanks, Christine. Thanks also Mohan and also Adastra for inviting me to this World Intellectual Property Forum, and thanks for other speakers and panelists as well. So I'm from this company called Plus Solar Systems, Senin Berhad. So what we do is we are a clean energy solutions provider. What we do is we provide solar panels, PV systems to help our customers, to help SMEs, commercial and also industrial buildings to save energy. And apart from that, we are also doing our own AIoT solutions currently, and we see that as a need to continue to innovate and also to provide more solutions, especially Malaysian developed in-house solutions to facilitate the energy savings segment. So dealing with this sort of timing, economic uncertainty, such as the COVID-19 right now, the crisis. So what we're doing is that we're still in the midst of this MCO, and our company is still actively pursuing R&D activities. So we just carry out, for example, like speakers that we've shared just now. Pretty much we're doing our own R&D activities. We're writing codes. We're doing our own hardware designs at home. and all these activities are still being carried out as normal with our team working remotely. So we're still moving forward with what we have planned previously, even with MCO. As such, we're taking measures, to try to secure our intellectual properties. We believe it could launch us to another new heights post the COVID crisis. So we're doing all the preparation works that we need to do right now, filing the patents and then getting the designs and getting nailing down the fundamentals. So that help us to move much quicker post COVID situation. So as for our business, given the restricted movement period right now, our bread and butter solution right now is still the solar PV solutions, which majority of them offer us we need to deliver. The deliverables need to be done on site, require site executions. We are unable to do that part of work right now, but other than that, our other teams, like for example, the R&D teams, we are working harder than even usual to come up with more proprietary technologies that could help the company to pivot into post-COVID business models. Like for example, one very clear trends that we're seeing right now is that after COVID, there will be there will be a need to have more social distancing rules. There could probably be the need to have people are getting temperatures tested before going into buildings. So we're thinking of merging these sort of spaces together with energy systems to see how these sort of things can be blended together to become a more coherent and also to serve more purpose after the COVID situation. So going to the third question, IP, yes, they are territorial in nature. What we view that is that, especially as right now, we view that more as an as-needed basis, and we initiate actions into try to protecting our rights in foreign countries as soon as we identify, that if there's an opportunity for us to go into other countries, then we then consider to file in conjunction with the protections in some of the countries. So we do it as needed as we identify the opportunities to enter these foreign markets for our solutions. There's a fourth question actually that's not being shown here. What are my two top advisors for IP or technology-driven SMEs in maintaining or surviving in this economic climate? So throughout these past months of MCO, we have learned an important concept in surviving this economic climate is that is to three things. That is to relearn what you know, rethink, and also repurpose. And I believe the same concept will also apply to tech-driven SME to survive this period as well, to be agile and then to pivot into unknown or even uncomfortable spaces in order to bounce back much faster than the competitors when all these uncertainties are past tense. That's all my view. Thank you.
Thank you, Mr. O. So we are excited. So we hope to look forward to some exciting solutions from Solar Plus on merging some of these the needs that is being forced on by COVID-19 with energy systems. So we look forward to some exciting technologies from you. Okay, so I will go now to the next speaker, Mr. Jasdev. So Mr. Jasdev is the managing partner of Jasdev Chambers. So, with the one question that ultimately is, okay, all the protection and the filing, but ultimately, does it work when the crunch time? So what do you do? How does it work? And what is the actual, how does it happen? How does it take place if there is an infringement or you need to enforce your rights over the marks that you have protected? So I will hand over to Mr. Jasdev to take the floor.
Thank you, Christine and Mohan as well for giving me the opportunity to address the forum. Now, of course, intellectual property rights are very, very vast. So my focus today is just going to be on the enforcement of trademarks. As a specialist IP firm, legal firm, we have been carrying out a lot of enforcement actions over the years. I've been doing this for the last 21 years now. And it is, we have the necessary laws. In fact, we've just tightened up the laws further last December. The new Trademarks Act has come into force. So we have all the necessary legal framework for carrying out enforcement. And I would say that actually we are one of the better countries in terms of where enforcement is concerned. Now, insofar as trademarks are concerned, there are various options available. Of course, if you have a registered trademark, you have the option of criminal enforcement, a civil enforcement, that means where we go to court or we issue a cease and desist letter, or we can do a combination of both. We can start off with a criminal action and then follow up with a civil action thereafter. So now, in terms of criminal enforcement, criminal raids and all that, these come under the purview of the Enforcement Division under the Ministry of Domestic Trade and Consumer Affairs. They have extensive powers of search and seizure. The action is very simple. They are initiated by letter of complaint. Of course, the letter of complaint has to have certain criteria, necessary required documents and information that they need to be sufficiently given to them before they proceed with the raid. And then they proceed. They seize the goods, and once they're confirmed, be counterfeit by the proprietor. After investigations are completed, these goods are actually forfeited and they actually destroyed eventually. And as far as the infringer is concerned, they will take a criminal action against them. Either they are offered a compound, which is a very high fine is imposed, or sometimes they even prosecuted in court because the amount is quite substantial. The seizure is very substantial. The value of the seizure is very substantial. They are actually prosecuted in court, and so we've had very many cases where we've taken them to court as well. Now, insofar as civil enforcement is concerned, we would usually, either it follows after a raid or we go directly with a civil, because sometimes when the mark is not identical, we can't do a raid. So we will go with a civil enforcement. So where trademark is concerned, we issue a cease and desist letter, basically a letter to say that can you please stop doing this, and can you please refrain from doing this moving forward as well. So this will usually be accompanied by a letter of undertaking, which we require from them, and where we get them to admit their liability, acknowledge the rights of the proprietor, and basically promise to undertake not to further infringe the trademarks in future. We want them to deliver up any infringing goods that they have. We want them to also, disclose the source of the products. So sometimes we can go up the value, the chain of, supply, and go down to the ultimate, the manufacturer sometimes. And ultimately, if we're lucky, we can even get them to pay some costs and damages. So, and of course, the disclosure that we get from them is through by way of a statutory declaration. So they've given an oath so that we can take action against the supplier. And of course, if let's say they don't respond to a letter, or if we find that it's serious enough, we can, initiate a civil proceedings in the High Court. And in fact, in Malaysia, we have a dedicated IP court which is based in Kuala Lumpur, which has been in place since 2007. And of course, if you take a civil action, then you can get your remedies available by injunction. You can get a discovery order. You get a delivery up order where you can deliver up the infringing goods. We get them to pay get an assessment of damages, so get them to account of the profits that they've made, get them to pay costs, and various other orders that we can, ancillary orders that we can get them to online enforcement, online infringement that takes place, and how do we, the challenges of going to online enforcement. What do we do? Are we able to do it? And we definitely can, because it's a where we find some things online, we can either lodge a complaint with the a website, for instance. We can even lodge a criminal complaint, and then the Enforcement Division, the Ministry of Domestic Trade, will do their own investigations, and they find a sufficient basis. They will then liaise with the Malaysian Communications and Multimedia Commission to block or take down the access to the website. So we've had that. Or sometimes even if they find that they are making, because it's illegal transactions involved, so it comes to anti-money laundering, they can even freeze the accounts of the infringers as well. It's quite drastic action that they can take. And then sometimes we've come across where you find a lot of Facebook Live audios, videos going on, and we do investigate them, find out where they are. We can even carry out a raid against them, seize all the products. So it's quite drastic sometimes what we can do, and based on the laws that we have today. And once we know who they are, we can even send a cease and desist letter.
Okay.
Now, so I would say that the enforcement is relatively effective. Criminal raids can be done within 1 or 2 weeks sometimes even within a day or two if you're lucky. In terms of civil cases, a cease and desist program, which targeted to a certain area where we want to clean up, and has proven to be effective strategy. And insofar as the courts are concerned, that we're actually quite fast. The IP court actually carries out their cases from the time you file it until the time you get your full hearing or trial. Can take up to 7 to 12 months and you complete. And it's quite surprising, because for everybody to know that we actually sometimes a bit faster than even the Singapore courts. So,
okay,
and
that's
we've
good
been
to know.
acknowledged on the international scale.
Okay,
Yes.
that's good. Thank you, Mr. Joseph. I think that there was quite a very comprehensive overview of what are the recourse that is available.
Sorry,
Perhaps,
can I just summarize?
Sure.
I'll skip the examples that we have, but maybe just advice for SMEs in the tough economic environment. Perhaps what I can say is, please make sure that your IP is registered. That's very important, especially your trademarks. If you don't have a registered trademark, you can't do criminal enforcement. So you must have a registered trademark. If you have your IP which is halfway, don't abandon it, get it registered. If you have IP which has been registered, make sure it's renewed and it's kept valid. All right. So be vigilant in looking out for infringement. It starts small, and it's cheaper to get it enforced when it is small, and it can be done faster and more effective, rather than waiting for it to become a very big problem, then very more difficult to tackle. And so I think this is one of the major takeaways that we can for the SMEs at the moment. I have had a few other points here, but we have time constraints, but I would not go into it. But I think the major thing is get your IP registered.
Okay, thank you so much, Mr. Joseph. So what I'll do is I will just hand it over to, so we are 1 hour into this forum, and I noticed that most of us are still around. Thank you very much. So we'll just have a quick wrap up, summary note by Mohan, and then after that I will open, I have already received some questions from the floor, then I'll just direct some of this question, and then we can wrap up for the day. Mohan, over to you.
Yeah, sure, thanks. Just a very quick one. I just want to explain exactly what's happening right now. I mean, because of MCO, what sort of inquiries are we getting where our IP firm is concerned? So let me give you a few examples. I mean, one is on trademark, taking cue from what Justin just mentioned. File your application, your trademark application, and get it registered. That's happening right now. I mean, clients are coming to us because most of businesses now, I mean, because retail outlets are all closed and you can't really go out. So most of them are looking at how do we go and sell our products or services online. So when they go online and they want to go and use this e-portal, e-commerce platforms, one of the requirements for some of these major portal platforms is you need to have a registered trademark. Only then can you put your product up. So they're coming to me now and they're saying, I need a registration within more like yesterday. And we say it's a bit impossible. It will take, typically in Malaysia, it'll take about 8 months. We'll give them some other options, like, you file in Singapore period. So they are coming to us now and they're saying, we want to go online, but we need to get a registration. So what I'm trying to tell most of the SMEs here is file your trademark soon, because when you think of going online, you would need a registered trademark in most of the major portals, e-commerce portals. Okay, next thing that's happening is there are many inventions because there's this pandemic and COVID problems. So many inventions related to this as well. We've got a client who came up and said that when you wear your face mask, it takes a bit of time. You need 2 hands. So they came up with an easier method for wearing your face mask, where it's more like there's a face mask attached to a spectacle structure. So when you just how you wear your specs, just wear this, and you just use one hand and you just put your face mask on. They came up with some invention like that. So we just protect invention, and so as soon as we protect invention, he started communicating, because he can't to OEMs, plastic manufacturers who manufacture products for other people, and he's communicating not only in Malaysia but also with another company in Latin America, because he's looking at that market. He wants to go in a big way, Asian market. So he's communicating with them, and it's possible because he's got a patent. Now, if he did not have a patent and he shares this idea with one of these manufacturers, most likely the manufacturers look at it and say, thank you very much for the idea. I don't really like it so much, but at the back, they'll start manufacturing it. There's always a possibility. So now that he's got this invention protected, they have to talk to him because they have to respect that, he's got the IP protected. They have to respect it because otherwise he can go after them. So that's another benefit. I mean, so by just sitting in his house, he's not opening up another manufacturing plant. He's just working with another manufacturer who produces such products. And the reason why this is possible is because he's got a patent for this invention. Now, the final one I would like to just share again in regards to this period MCO. You see a lot of memes coming out where Malaysians are so creative. They come up with really funny memes, and they're coming up with some songs, creative songs also relating to COVID, using well-known tunes, but they come up with their own lyrics. These things can actually be protected under copyright. So sometimes, when you create a memes, they just put it out. They don't realize that the memes, at times, it can take a life of its own and it can become very famous. So one example is the one you can see on the screen: keep calm and carry on. This was something which was done very, very long time back. But in this past 10 years, it's become a bit more well-known over here, especially as a meme. So now, you also see something like keep calm and stay home. You'll come up with something like that. So this meme has become so well-known. The first person who created this meme, unfortunately, it was created about maybe in the 1940s or 1930s during the World War. They were saying keep calm and carry on. This was actually created then. But I'm saying, as an example, if someone comes up with something creative like this right now, they can actually protect this as a copyright. So anyone else who comes up with a similar thing, because as I said, this meme has taken a life of its own. Anyone who comes up with something similar, they have to give recognition to the author of it. So it can be by means of, you can do it, when you come up with one of these memes, you just need to put at the bottom, copyright, at least you get some amount of recognition. Also, right? Some of the things that is happening quite a bit with
Can hear you.
Sorry, because I'm having a bit of my connection is a bit unstable. So, but okay. So with that, I would like to, because we have overrun the session for half an hour now.
Hi, Christine. Hello. Yeah.
Sorry, I'm okay.
Okay, now.
Okay, I'm back. Okay, so basically we have already overrun the session by half an hour, and I think we have a few questions that is made available in the chat window. I think Prof. Dato' Noraini has answered one to the participants. For the other questions, I think what I will do is we'll take it offline, we'll get it answered, and then we have all your registered emails, and then we will then share these answers to you accordingly. So I hope that is the plan that is okay with everyone else.
But if anyone has any pressing questions, if they just want to post the questions, can we just allow them to post maybe one or two questions?
Yeah. Okay. Yeah. So there is
anyone just come up and just ask any questions here.
Yeah. Okay. There is just now I saw there was a list of questions. Unfortunately, because I think I was logged off. Yeah.
Anyone online who just has a question, they can just pose a question. If not, we can just end this session.
Yeah. There was some questions posted earlier, but unfortunately, I think when I was logged out, I don't see the questions anymore.
No, sorry, but can't you just ask them? That's how I said.
Yeah, for those, maybe if you want to ask a question, you can unmute yourself and then just throw a question, and you can pick any of the speakers that you want them to answer. Okay, so there is a question that just came in through the chat group to Mr. Jasdev. What is your expectation for IP proprietors to invest in IP enforcement, particularly civil suits in the present situation?
Basically, the cost. Okay.
Yeah.
Yeah.
How much is it?
Well, of course, civil suits are going to be an expensive strategy to say, okay, look, we're going to sue everybody. That's going to be a very expensive thing. But of course, like I said, if you're going to have a trademark enforcement strategy, there are various ways to go about it, from the most cost-effective to the most expensive. So you can have a combination of several things that you can do. So if you carry out 1 or 2 raids, and then the smaller ones, the smaller infringers that you have, we do a couple of cease and desist letters. So you stretch out your budget. So you have a certain budget, and then we say, okay, look, I think you can use this to do various different actions that we can take. So for instance, a cease and desist letter may be the most cheapest option sometimes. After a couple of rounds of communication, they will come and say, okay, fine, we will stop this, and we will sign an undertaking, and we will, we are happy to resolve this out of court. So you don't actually have to go to court for every infringement that takes place. It may be different if, let's say, it's a very complicated patent suit infringement that's taking place, and then of course you file a patent suit. But for trademark, most of the time, a cease and desist letter would suffice. A raid is a very effective tool that we can use, because it's relatively cheap, and we get the work done, we get the goods off the market, and then leave the government to prosecute them. And then after that, we can follow up with a letter and get them to
Yeah. Hello. Okay. Okay. So thank you, Mr. Jasif. Okay. Now, so there is another question that just came in. One participant is asked whether, for example, a patent process can be shortened. I would say reduce. So I think I'll paraphrase the question. Can the patent process to be shortened to assist the implementation and entry of the product to the market? And I think, Dr. Amir, earlier I saw your comment that you are also in support to making it easier to enter the market. Maybe Mohan, you can answer this question. Mohan, sorry, I think you have to unmute. Can you unmute?
Okay.
Okay.
Is it okay now? Is it
yes,
all right now?
Yes, I can hear you now.
Okay. So, I mean, we have, firstly for patent, I mean, when you file an application, the filing date is most important. So as long as you have the filing date, that's good. So you need to have a filing date. I do admit the patent office sometimes can take a bit of time before they grant a patent. But as I say, the filing date is very important for the first application. Now, we also have a way of expediting the application. So you can expedite the application and get the application granted within the span of about 2.5 years. It might look long now, but honestly, in the whole process, it's not that long, because when you start the whole process of patent and commercializing your patent, 2.5 years is not a very long time, because by the time you start talking to people and getting some interested parties and all that, it will take a bit of time. So 2.5 years is a good enough time. Even in US, it takes about 2 years for one to get a grant. So we have a means of getting it within 2.5 years, so that's a possibility. Now, another thing of expediting the whole process is in Malaysia, if you have a patent filed and granted in US, UK, Europe, Australia, Japan, and also Korea, automatically the Malaysian Patent Office will just grant the patent automatically. So if you really want to push the patent office, then maybe you file a corresponding application in one of these countries, which you think they are pretty fast. So once that country patent is granted, then automatically the Malaysian patent will be granted. I mean, you just need to go through a particular process and you can get it granted. So that's another way of expediting. So there are a few techniques to expedite. So the person who posed the problem, we can always talk to that person. And if she's facing any issues getting the application granted fast, we can always talk to her. But the most important thing, as I keep emphasizing, is the filing date. You need to make sure you have the filing date.
Okay, thank you very much. Okay, so there are no more questions that came in recently. So I think with that, we can conclude the session. Any other final words from the speakers before we sign off? Okay. So
that's it. I mean, we've already passed the time. So
just one final word. The topic was on food security for my questions, but I just want to highlight in terms of the either learning programs, products, because now during this MCO, the e-learning is ongoing. For universities, actually conduct 100% online now, or even school. You're talking about students studying anywhere, so the infrastructure. So when we talk about IR 4.0, so we have to move on in terms of the supporting facilities for infrastructure as well, the infrastructure. So I think that is something need to be addressed as well in terms of what the country needs.
Okay, yeah, thank you so much for that comment.
Because, you know, they create this through the augmented reality, you know, to the IP process, we must have copyrights. But at the same time, in terms of commercializing the modules and products, I think the SPI, I think a new source of economic support, but transaction in terms of financial. But you talk about education, it's endless. You know, it's just that it's call for creativity and doing something differently now. In terms of
University Terengganu should come up with their own brand of online modules.
These are ongoing, and I think people are putting their heads together and to have this module in terms of assessment and the teaching modules, the examination and so forth. Thank you.
Okay.
Okay, thank you, Prof. Dato. So with this, I thank everyone for taking the time, sparing an hour to be with, to attend this and to share your thoughts and knowledge. And so I wish everyone all the best and stay safe. And we hope to engage with you again, maybe through another forum. Thank you so much again, everyone. Thank you.
Thank you. Thank you,
okay,
everyone.
bye.
Thank you. Thank you.
Thank you. Yeah, thanks.
you.
Thank you.